Hello, everyone. I am Dr. Garima Gupta, Assistant Professor of Law at National Law School, Bangalore. And it is a pleasure to welcome you all to today's panel discussion on India's evolving data protection framework under the Digital Personal Data Protection Act 2023 and the recently notified Rules 2025. This discussion is being organized by the Chair on Consumer Law and Practice at National Law School, Bangalore, in collaboration with the Advertising Standards Council of India. The DPDP Act and the rules together introduce a structured framework for personal data protection built around concepts such as valid consent, specific purpose limitation, data minimization, children's data safeguards, and rights and duties of data principles. The compliance architecture ranges from fleshing out obligations for data fiduciaries to enhanced responsibilities for significant data fiduciaries and extends to categorization of data processors and the mechanisms for their phased implementation. Consequently, we are at an inflection point where organizations must think about practical questions. How do consent mechanisms evolve? What does purpose limitation mean in dynamic business models? How should companies prepare for sector-specific obligations and cross-border considerations? These are precisely the themes our panel will unpack today, drawing from legal, regulatory, and industry perspectives. We have with us an exceptional panel of speakers whose combined expertise gives us the rare opportunity to examine the Act and rules not just as legal instruments, but also as frameworks that affect day-to-day operational realities, business models, technological choices, and consumer trust. We firstly have Ms. Manisha Kapoor, who is the CEO and Secretary General of the Advertising Standards Council of India. She also serves as one of the 4 global vice presidents on the executive committee of the International Council for Ad Self-Regulation. Ms. Manisha brings with her more than 25 years of brand building and marketing experience. She's a regular part of consultations on advertising policies with regulators and ministries. She has been instrumental in ensuring that advertising self-regulation keeps pace with the fast evolving landscape, especially in the context of digital advertising. We welcome you, Ms. Manisha.
Thank you. Pleasure to be here.
Thank you. Next, we have Mr. Ghanashyam Hegde, who is the Vice President and General Counsel at Procter & Gamble for the Indian subcontinent, Australia, as well as New Zealand. His key areas of expertise include strategic legal advisory, risk management, and compliance. Being at the forefront of navigating complex legal landscapes in large consumer-facing organizations, he has played a key role in steering complex legal and policy issues for one of the world's largest consumer goods companies. He also serves on the board of directors of Procter & Gamble Hygiene and Healthcare Limited, where he is the executive director and company secretary. We welcome you, Mr. Hegde.
Thank you.
Next, we have Ms. Lagna Panda, who is a partner with APN Partners. She specializes in competition law, data protection and governance, and consumer protection laws. She has advised and assisted clients in cartel investigations, abuse of dominance investigations, merger control filings, and advisory matters. She also regularly advises on data protection frameworks and data governance matters. Recently, in 2025, she has been recognized as a future legal leader by India Business Law Journal. We welcome you, Ms. Lagna.
Thank you, Dr. Gupta.
Lastly, we have Mr. Shashank Mohan, who is a lawyer and tech policy researcher based in New Delhi and is the Associate Director at Center for Communication Governance at NLU Delhi. His work primarily focuses on data protection, data governance, surveillance, intermediary liability, and e-governance, and he has been thinking deeply about these issues for the last 8 years. He has also conducted research on intermediary liability, social media regulation, surveillance law, global tech governance, and more recently, AI governance. We welcome you, Mr. Shashank. We once again extend a warm welcome to all our panelists, looking forward to an engaging and insightful discussion. Without further ado, I'd like to begin by inviting each panelist to share their thoughts on the Act and recently notified rules from the vantage point of your respective work. So may I please request Ms. Manisha to initiate the discussion?
Thank you, and welcome everyone to this, the first of its the combined NLS CLAP and ASCI webinars on legal regulatory issues. And we hope that this will only be the first of many to come. So really glad to kick off this series, and big thanks to the NLS team for charting the agenda and putting this down. And I think the topic of DPDP is a contemporary one, is something that we are all currently in the midst of figuring out and navigating. And certainly I think these conversations are helpful as we frame our thoughts around it, and learn from each other in terms of best practices, approaches, and how we kind of think about this. So just I think to build the context, of course, the internet was built much before the modern concept and understanding of privacy, that has come about in the last few years, particularly so across the world. I think in some markets like Europe and US, it's been discussed for a while longer, but, now it's kind of a universal, understanding. But I think to understand the idea of privacy and also how it relates with what the internet has enabled, I think that context is useful for us to keep in mind as we think about, the implementation of DPDP and just how we approach it as organizations. I think it's important to acknowledge that for SMEs, the idea of being able to get onto digital ads and, address audiences that may be interested in their services has really been the bedrock of how they have been able to grow and expand their businesses. So, it's important to kind of keep that in mind. It's also important to keep in mind that consumers who are now used to no cost of access to the internet and all the services and goodies it provides, is also based on an ad-based model. So you have access today to media, to internet, to entertainment. I think particularly in India, of a kind which is at a cost which is not there anywhere in the world. And also, how we kind of experience the internet, which is infinite in nature, that experience in some way becomes more meaningful to us when what we see is relevant to us. So, these are all the various factors that play into when we think about privacy, but when we also think about how we want to experience the internet. So this is really on the one side, I think, what it has enabled. But I think also, we must equally recognize that today perhaps consumers are inundated with consent requests that are coming in. And I think, I can certainly speak for myself, but I think also for most of us, if we think of ourselves just as consumers, we are probably saying yes to a lot of things without fully understanding the implications of what we have said yes to, because we want to get to the other side of, that question and get on with, experiencing what we have gone out to seek. Companies also now bound increasingly by legal scrutiny, and particularly with the DPDP rules having now been notified, will have to present consumers with intricate clauses and granular consent. This is all part of now what the regime demands of all of us. And I think the challenge here would be, how do you therefore balance this need for more information and consent, as it were, but how do we make it a more meaningful exercise versus an exercise that is necessary, but something which may not always necessarily be very meaningful for us. The other factors I think we need to think about is, the fear of frauds and scams, and, how does that really play in terms of our understanding of privacy, our understanding of, what data we are sharing. And, that I think, again, across the country and in many parts of the world is becoming, an issue. And particularly, we hear of things like digital arrest, et cetera, where you are just fearful of what the internet is asking you to do. So I think the way we go about this is, how do we build, privacy by design? Because now to kind of lay privacy over an existing infrastructure is certainly difficult, certainly challenging. Of course, it needs to be done, but increasingly, how do we start looking at privacy by design where it's built in? I think organizations will have to gear up in terms of audits, training, and really look at how we balance this need for privacy, but also think about the progress that the internet is making for us. And I think from our point of view, it's important that we see both of these as both desirable for consumers and for the industry, which is the need for privacy and the need for progress, the need for exploring all the possibilities and opportunities that the internet brings to everyone. Even look at content creators. I mean, think of that whole kind of an segment of an economy that's got added to the country. So I think I just wanted to kind of lay this down as the framework through which we would like to look at and evaluate, what we do next, because it's important to have privacy and deliver it from a point of view of compliance, but also always kind of ask ourselves a question saying that what is it? Is it enabling? Is it meaningful? And how do we make it more meaningful as we go along? So I think I'll end what I have to say now, but I'm sure we'll have some questions later and some discussions later. But yeah, back to you, Garima.
Thank you so much. And that was a wonderful beginning point, because we have to balance information and consent. That's how the market functions now. I'll now reach out to Mr. Hegde for his views on the law and the rules from his sector.
Thank you, Dr. Gupta. Thanks, Manisha, and being part of this, sharing my... Can you hear me? I'm audible?
It's a little patchy. Now
okay.
You're audible.
So
now it's
okay,
better.
fine.
Yeah.
Okay. Is this
yes
more clear?
Yes.
Okay. So thanks. And then as I was just saying that it's a pleasure to be here and talk about this very important change that Indian industry, Indian business sector, as well as the Indian consumers will go through the next 18 months and how transformative this is. I'm probably I'll contextualize this in three buckets, right? One is on law. The other is on how does this impact on companies like us and our operations, and perhaps how both of this will get defined by what the realities of India as a country and is, right? We have the act and the law notified in November. We are already on the path of implementation in a phased manner for the next 18 months. And let's not underestimate the power of this legislation and what it is to deliver to the consumers of this country. At the outset, to me, a DPDPA regime turns personal data from free-for-all into a licensed resource. The price of the license is informed, revocable consent and strong security, right? This is the biggest change, right? This what we today don't value or as a resource is now getting converted into a licensed resource for which the price is licensed, informed, revocable consent and strong security, right? And this act will serve as a cornerstone for India's evolving digital regulatory landscape, paving the way for some of the planned legislations like Digital India Act and sector specifications regulations from entities like RBI, SEBI, and IRDAI, right? So each of them are stages of their own evolution as prospective laws, on the digitalization front of our economy, and this will be the cornerstone of each of those legislations. And this sits on top of an enormous digital market, nearly 1 billion internet users, rapid AI and ad tech growth, and historically very patchy consent culture, right? So that's the context in which we are talking this legislation. Although this legislation has been in the making for the last 8 years, and in implementation after the legislation was notified for the last 3 years, but it's a amazing transformation that this heralds from here on, right? The framework of the law is, we think this is very practical. It is designed to be user-friendly and is supported by extensive public consultation that this legislation has gone through. Imposes significant responsibilities on organizations, which is fair. If you want to use, you got to be responsible for safekeeping usage as you promise to the data principle. The goal is to create a safer data ecosystem that fosters innovation and benefits citizens and enhances trust in digital governance, right? And true to this intent, the entire digital data regulatory framework under this law is envisaged to be digital. As you know, we all are now coming to appreciate the Data Protection Board, which is being incorporated and established under this law, is envisaged to be entirely digital, right? For the first time in the history of India, a statutory bodies is incorporated with original design to function in a digital-only mode, which you can imagine the ease of access to citizens and what it promised to deliver as justice. Now, coming to companies of our size and principle, we recognize our role in bringing this transparency to life. Our ability to embrace DPDP is essential for navigating a future increasingly prioritizes our regulation, transparency, and trust in the digital realm. Many of you, we would have. I'm hopeful that we would have touched your lives one way or the other way. Has been around for more than almost 200 centuries, almost 2 centuries, or 200 years, right? Purely because of the trust our consumers and stakeholders have in us, and we are prepared to do what it needs to continue to earn that trust every single day. And personal data, right? Now, I also want to spend a few seconds on where are we in the context of all of this, right? While DPDP Act marks a significant progress in the space of protecting, it's important to acknowledge that consumer awareness regarding data privacy remains really nascent, right? How many consumers are truly informed about their rights under this new law, right? Although the comprehensive data about this is scarce, informal studies say that about over 50% of consumers may not even be aware of their rights related to personal data. How many times parents have understood that their children's data requires explicit parental consent? It is just shared without even a second thought, right? So in that that's the context, that's the reality in which this beginning has been made. In our view, this will go a long way in creating awareness about the rights of data principles, and DPDP Act is steering India towards a more secure, accountable, and rights-oriented digital ecosystem, and which is what we have been, for example, Europe, which was way ahead of us in doing this, has already laid the path on how multinational companies like us would operate in this space.
Oh, okay. Thank you so much for that. There were a couple of really interesting points on the licensed resource part and the rights bit and how the concept framework was still now very patchy. I'll now move on to Ms. Lagna to invite her to give her thoughts on the law.
Thank you, Dr. Gupta. And so good to be here, so good to be part of this panel. It was great to hear Manisha and Ghanashyam, talk about interests of varying and different stakeholders and genesis of this new data protection framework that we have in India. As a lawyer, to be very honest, when I first read the final rules, I genuinely thought to myself that there is a lot to wish for, because it's not very different from the draft rules that we saw, which were published in January for public consultation. I mean, there are a few, I think, changes and modifications in the final rules, and some additional obligations have been brought in. But broadly, I think it's similar to the draft that we saw in January. The legal requirements continue to be very prescriptive in nature, and operationalizing these legal requirements it's going to require a lot of effort, and of course, there will be a cost to it for organization. And this is something that Manisha sort of spoke about balancing different interests. And India as an economy, if you look at it, it's our economy, about 25 or maybe 30% of our economy is supported by SME players. And the cost of compliance for these SME players is going to be substantial, if we look at their profitability or their revenue. So larger organizations may find it easier to sort of comply with these new norms, but it's going to the cost is going to be relatively high for smaller organizations. And while the central government has been given the power under this law, to exempt classes of data fiduciaries from certain compliance requirements, including startups, we'll have to see how that plays out and what sort of data fiduciaries, are given exemptions under this law. So that's something that's still very open-ended, and we don't really know how things are going to play out there. There's one more theme that sort of really stands out for me as a lawyer when I look at the legislation and the implementing rules, is that there's no harm-based qualifier for most of the obligations that have been proposed by the law. Whether we talk about breach reporting, whether we talk about DPIAs, when DPIAs should be conducted, when audits should be conducted, or when targeted advertising or behavioral monitoring should be permissible or not permissible. So there is no harm-based qualifier for any of these restrictions or limitations or prohibitions that have been proposed under this law. And because of this, I believe there are some proportionality concerns with these obligations. But yeah, I mean, those are my initial thoughts about this law that has sort of now been made effective, although substantial provisions will become effective only in May 2027. Now, having said that, I think organizations are sort of planning to review their policies and data flows, agreements, and all of that. What I think will be useful for entities out there who are sort of structuring and figuring out how to go about planning their compliance journey is to maybe have an overarching governance framework and guidance for its management and employees, because DPDP compliance is not going to be a one-time exercise. It's an ongoing compliance. Every day, what you do, what the business does, what the employees do, what the management does, it has to be compliant with what the law says. So having an overarching framework, some sort of policies and guidance for everyone is going to go a long way in ensuring compliance with this new law for various organizations. So those are, some of the initial thoughts that I had on this law.
Thank you so much, Ms. Lagna. It was nice to have a sense of the legal perspective and rather the enforcement perspective, especially after the previous speakers talked about the market and the consumer bit of it. Now I'll move on to Mr. Shashank to know his thoughts on the law and the rules.
Thanks, Professor Gupta, and I'm going to provide some different perspectives. I do agree with some comments that Lagna made about there's a lot of wish for from the act and the rules both. And one of the points I have is we've been talking for a very long time about harm-based regulation, at least articulation of broad harms that will give guidance to companies, that will give guidance to the government, that will give guidance to enforcement agencies. I think that's significantly missing. And now, we'll see how the act gets operationalized. But sort of stopping there and coming quickly to some broad points I wanted to make. I think one of the things we've been writing about a lot is how the Data Protection Board is formed, Professor Gupta, because eventually a law is only as sort of important or significant as the enforcement. I know India's had a very as lawyers, we understand tricky legacy with enforcement of laws, but especially a technical law like this, and I think Ghanashyam was also mentioning this, where there is such low awareness in the masses. The Data Protection Board is currently just a quasi adjudicator, right? If I may use legal terms here. And it really only has the power to put penalties, right? And I wanted to bring this up a bit later also, that just imposing penalties will not be enough in our view, in my view. You need sort of proper investigations, you need compliance proof, you need to see policy changes to really change incentives that companies have to collect data en masse. I don't think just fining them or adding penalties will really change things. But yeah, my first challenge is the way the Data Protection Board operates, largely an executive appointed board with very, very curtailed powers. If you look at some of the previous versions of the law, we had there were many more functions like public awareness, like some regulatory powers. I've been talking about this for a very long time, that India needs a independent regulator for tech matters. If I can use a very recent example, the Competition Commission of India had fined WhatsApp for sharing data between its entities, Meta's entities, and there was an appeal filed in front of the NCLAT, and the NCLAT has sort of, again approved the fine. But why is the Competition Commission of India and NCLAT doing this? I mean, it's their job, but they're seeming to be more progressive than, in some cases, the courts or other entities we have. And what will happen to this kind of enforcement once the DPD comes to power, right? I think there is policy fragmentation a lot. A lot of us have been reading about Sanchar Sati app, SIM binding rules. Like, there's a lot going on, which brings me to my next point, that again, as a lawyer, and I'm guessing talking to fellow lawyers, this came out of the Puttaswamy judgment, right? And the state is completely exempted from this law, which I don't think as a lawyer is proportionate or as per what Puttaswamy suggested, right? So there, I think, is a possibility of a constitutional challenge to the entirety of the law in my sense. So that's the other point I wanted to mention. I think the third point, which I've been writing about for a very long time, is the overemphasis on consent. Right? It doesn't really work. I mean, I don't think that you have to be technically aware to understand that online consent is basically an eyewash. And why should the burden be on average citizens when when citizens of India are not able to meet their daily nutrition requirements? How can we put the burden on them to understand what companies are collecting and how should they protect their price? I think the burden should be primarily on the people who stand to benefit, right? Which is largely corporations. I'm not talking the state, because the state is by design exempted from this law largely. But I'm saying that the entities who stand to benefit and make money from our data, they need to be responsible. And we need to, in our laws, we need to have strong statutory obligations on them and strong enforcement, right? So that's our perspective. Yeah, and I heard about like consultation being wide. I know for many years the government has done consultation. But again, as a constitutional lawyer and talking about transparency, we have not even seen one single comment the government has received as comments on the data protection law, right? That's not meaningful consultation. I've spoken to the government about this myself. They have run many good processes to try through other processes through the Ministry of IT themselves, where they have published comments, where they've taken counter comments. I think in India, we need to make lawmaking much more consultative. When our parliament is not functioning as per it should, at least we need to ensure that we're listening to citizens and publishing those comments. So I think we need to start talking about a real meaningful shift in power, and how can we enable that in the market economy, data market economy.
Thank you so much. This opening remark, all the panelists' opening remarks have, brought us to think on many perspectives. Firstly, while there is an overarching law which tells us what to do, while we can say that it is a good step considering the way the markets have changed and considering the quantum of data that is being collected, we also need to look at the law with some sort of or some level of trepidation. Most particularly, I think this harm-based aspect which was highlighted is very important, especially because nowhere in the present rules or the act we are talking about categorizing any wrong on the basis of severity or the injury that is being caused. And there are these penalties which have been put, which are really high. The ceiling of the penalty is very high. So maybe that's a very important point, and I think we'll take it up further. If I may, I would actually want to ask the first question to Mr. Shashank itself, because it's on the, I want to talk some on the categorization of personal data. So I wanted to ask you, the DPDP Act defines only personal data, but today data ecosystems include observed data, inferred data, behavioral profiles, and predictive models. How should we understand the scope of personal data? Because that is the heart of the legislation. And because particularly big data systems can cull out a lot of insights about a person directly without any identifiable information. Please.
I think this is a very important question. Sorry, I don't know if you want to say something.
No, I thought you were on mute. You're fine.
Okay, yeah. Thanks for this question. I've been writing about this for a long time. I think we need to really, and I'm specifically talking to the scholars, students, and researchers in the room, because this may be of interest, especially to you. There's enough literature out there to kind of cement the idea that companies, and so what do companies do, right? What is the purpose of collecting data? So that they can make some decisions about us, either to sell it to advertisers, or in some cases make decisions about us directly, right? So my point is, they don't need to collect personal identifiable data to do this anymore, right? As with big data technology, and big data technologies have been around for a very long time. We're talking about chatbots that scrape all our data anyway. And one thing I want to mention is this law, for people who have not gotten a chance to see, this law specifically exempts publicly disclosed data from its purview, which I think is absolutely in opposition to Puttaswamy judgment. In Puttaswamy judgment actually says that we still enjoy a semblance of privacy even in public. And if you just Google, again, for the researchers, if you just Google contextual privacy, you will get many papers. I think it's very important prong, which basically says that I share my information or I lower my privacy requirements depending on my content, right? Within my home, with my friends, with my family, I'm okay to share some information because of sense of trust. If I'm sort of posting my address on social media, that doesn't mean that I'm consenting to doxing, right, or harassment. So I think these are some important points to think, and I think we've not seen this in any other law in the world. So this is interesting, and I think specifically done for the AI industry, right? I'll be happy to listen to what others think about this as well. But yeah, so I'm just saying that unfortunately, the government of India began a policy process to make a non-personal data governance framework. I think that was an excellent process. I think it's kind of wanted to give power back to citizens in some ways, envision new data ecosystems like data trusts. I think there was a lot of new ideas, which we basically need to do now. We need to build new ideas, even if we make mistakes in them. And giving up that process, I think, has been unfortunate. I know at CCG, we ourselves sit on committees with the government on data management. And as our new AI work, we are really focused on how to ensure that we build data governance frameworks that are privacy preserving in the AI ecosystem. But I think that these questions are difficult to answer, because I feel that the Data Protection Act, by the time it gets enacted in 27, it will already in some parts be redundant, right? So we really need to be thinking about this. The government took 7 to 8 years, where there was the first version of the law looks 1,000 times better than the last version of the law. So I think we're in for my prediction is that this law will be a bit toothless unless the enforcement agencies really tighten the ropes.
Thank you so much for that. And I'll take cue from Shashank's response and move on to Ms. Manisha, especially because there's a further problematized idea of dark patterns. Now, ASCI has recently identified dark patterns as a major risk to consumers. And with DPDP's rules around consent clarity, do you see a tighter regulatory overlap? Will some of these dark pattern practices now become data protection violations and not just ad violations?
No, most certainly, I think, there will be overlaps. In fact, The study that we did about a year and a half ago showed that during the onboarding process, in fact, privacy was the leading violation. In a sense, it was the leading dark pattern. So I think if memory serves me right, I think 79% of apps had that as a problem, in the sense that consumers were probably giving more information that were needed to in order to use those services. So I think certainly it is there is a big overlap, and I think the good news in that sense with the data protection thing is that not all things that are onboarding are related only to advertising. I mean, dark patterns obviously come not just related to advertising, but in other steps of the processes as well, and therefore it kind of becomes meaningful to look at it beyond just an advertising lens. So I think that is something which will kind of come, and I think with AI, certainly I think things will become even more complex because the ability of just this widespread and all of that in terms of just the scale of whether it's dark patterns, whether it's privacy, etc. That could be manipulated in the hands of bad actors. But yes, I think that's something that we all need to be cautious about. Of course, technology by itself is not problematic, but I think the scale at which it could be misused, sometimes intentionally, sometimes I think not even intentionally. I think people also sometimes in organizations are perhaps not at the level of data maturity to even understand what potential harms may be caused by certain actions of theirs. So I certainly see that as a big area of overlap and something we all need to be extremely mindful of.
Thank you so much for that. Again, taking this conversation further, now, while collection of data is one thing, it heavily depends on the type of industry that we are talking about. So, with that question in mind, I reach out to Mr. Hegde, and my question to you is that, particularly in the FMCG sector and healthcare sector, hygiene sector, companies interact with millions of consumers, particularly through digital marketing. So, what do you see as the biggest challenge for high volume, rapid turnover industries in implementing meaningful consent and purpose limitation requirements?
So talking about the FMCG, health, hygiene sector in general, right? Consumer interactions are high volume and short cycle. Think of them contests, sampling, trials, coupons, influencers, and retail D2C journeys of some of the brands, right? Consent in these certainly been through it's implied through engagement, right? In the past. Now the law requires it to be explicit, granular, and verifiable, right? This creates three practical friction areas. One is speed versus specific, but each shift in purpose, retargeting, profiling may require renewed disclosures and fresh consent. Right?
Yes.
The second one, multiple touch points, releases, brand websites, distributors, wholesalers, cash on delivery KYC, influencer flows. Aligning one coherent consent signal is not a small thing. It's going to be it will require a bit of investment, planning, and enabling. Right. Then comes purpose limitation, as you rightly said, Dr. Gupta. Data or a consent cannot automatically be expanded for CRM or other purposes unless explicitly consented, which again breaks some legacy of practices which needs to be now changed. Right now, we see these as opportunities. Right. First, what does that how does those opportunities look like? The first opportunity, right? Build privacy first privacy models instead of random tracking of consumers, right? Second, depending on the strategic choices a business makes, or rather than rented reach.
I'm sorry, we are
Right?
losing you in between. I'm sorry to interrupt. We are losing you in between.
Is this any better? Not sure
Yeah,
it's got
now
to
I
do with
can.
this.
Now it's more clear, I would say. Yes.
Okay, all right. So let's hope it stays that way. So the second opportunity that I was talking about is depending on the strategic choices of the business, investing in first-party relationships rather than rented reach approach, right? And the third opportunity to, how we see this requires it, not because it is legal fine print, but embed privacy user interfaces as part of your brand or your corporate equity, right? And continue to drive the importance of data privacy within the organization. Take, for example, P&G, right? In P&G, data privacy is part of our culture. It's imbibed in all, right? The tone from the top and the processes that we have ensures that our employees are trained in doing the right thing on data privacy. They are aware of their responsibilities. We have already been at a certain level of maturity, which is even beyond what we were required to do before this law came into existence in India. This has not happened overnight, right? We have ensured that we drive this as a culture, and this approach has made it an everyday behavior where employees are, as I said, aware and responsible for data protection, not just of our consumers and third parties, which comes into from different gates into the company, but also of our own employees when we deal with it, right? And the second piece about preparedness of an organization, I would also say that from a reactive approach, it's good to shift to a proactive approach on this topic, right? Where in case of P&G, for example, our employees proactively assess the data needs and work with expert groups within the organization to curate the path that keeps them true to our overall focus on areas of transparency, minimization of the data that we collect, and the trust in how we manage any data that comes to us, be it of our consumers or of our employees, right? So this gives me the confidence that, large organizations with the right intent can make that a priority in the way they do business, and they will be able to work within the framework of this law, and more importantly, the spirit of this law, right? To acknowledge, recognize the privacy rights of the individuals that they deal with.
Thank you so much. Thank you for sharing the market perspective of data collection and especially that continuing consent problem that exists. With that,
Yeah, so
yeah.
in hygiene and healthcare space, responsible data use is not a compliance cost. It is a necessity, and it strengthens consumer lifetime value proposition over a period of time.
Yes, yes. On that point, I wanted to reach out to Ms. Lagna, particularly on the fact that while Mr. Hegde was talking about this approach wherein we have to shift from being reactive to being proactive and how it can be done. But given your background in the legal sector and enforcement and regulatory understanding of the laws, particularly, I wanted to request you to speak something about the obligations such as purpose limitation, data minimization, consent, and restrictions on data transfer, especially with respect to aggressive data collection, or also because the world is global now. This data keeps on moving from one jurisdiction to another. So what do you see as the biggest legal or compliance challenge for firms in general? Thank you.
Right. Thank you for that question. I think some of the panelists have already spoken on how, as a country, how personal data is generally processed. It has always been very consent heavy. And to be very honest, maybe explicit consent or express consent also may not have been there in most cases, where they may, in most cases, I think organizations simply give a notice. Or a prior notice in case of, in case they're collecting sensitive personal data. But since the enforcement has been so minimal, when we look at the SPDA rules and the IT laws, I think compliance has also sort of fallen back and has not really kept pace with how technology has evolved and how data is being processed by various organizations. So keeping that in mind, I mean, the law, as I said, is highly prescriptive in nature. It's very different from what we have seen under the SPDI rules. And DPDP compliance is not going to be a one-time exercise. It has to be an ongoing exercise. And Ghanashyam spoke about this. You may have you may have taken consent to process certain categories of personal data for specific purposes, but those purposes might change. Businesses pivot, and do you really need fresh consent or not? That's an assessment that has to be done regularly. As businesses sort of keep evolving, they branch out into new geographies, or they launch new products and services, or the categories of personal data, but they may not, the ongoing processing may require review if you're getting into new businesses, or launching new products, launching new product lines. So keeping that in mind, I think uh, it's it's uh, it's important to sort of have an organization-wide policy laying down principles, as I spoke about it earlier, and this is something that Ghanashyam also mentioned, that it's not just a compliance exercise. If it's about winning consumer trust and making sure that your businesses, it follows certain principles and certain parameters that are important for consumers. So a governance framework or governance policy will sort of lay out what are the principles and policies and protocols that all employees and management sort of need to keep in mind when they're going about doing business, when they're implementing, when they're launching new product lines, or putting in place new systems and new protocols. So that's something important. And purpose limitation and data minimization, I think, as principles, is going to be a game changer, especially for data principles. Uh, because if I'm giving consent to buy a particular product, there's no reason why I should give more information than what is required to sort of process that order and to take delivery of that product. So I think in terms of where data principles rights stand, it's going to be a game changer. But of course, I mean, it imposes a lot of compliance obligations on organizations, who have to reassess and review what sort of data collection policies they already have, what sort of legacy consent, they have taken, whether that sort of complies with the new consent standards that have been set out under this new law. So these are, I think, some of the things that organizations will have to keep in mind, and some of the changes that we are going to see that will happen, in the coming days because of this new law. So yeah, I think long story short is that compliance will have to be ongoing. It will have to keep pace with what an organization plans to do. Its future business plans, future growth, and all of that. And yes, there will be operational challenges, but I think that's just part of every law, every new law that sort of comes in.
Thank you so much for that. Taking this conversation further, because we identified many important threads from the perspective of the market, from the perspective of the law's understanding, and maybe few things on which the law isn't really clear. I also wanted to request the panelists to spend some time on the enforcement bit of it. Enforcement from the lens of the regulator, enforcement from the lens of typical types of producers or the market players. So I'll direct my first question to Ms. Manisha, particularly from the perspective of the supplier in the market. You were talking about SMEs. I wanted to take that conversation further. say small advertisers or independent content creators, as you were already mentioning, often lack dedicated compliance infrastructure, making them prone to violations because they're so small. Now, with the added compliance, which we understand will always be a continuing process, there would be a burden under DPDP. But how feasible do you think it will be for small players to comply, especially given the heavy penalty regime which has been put in the rules?
Yeah, so I think it's an interesting question, right? In terms of also, so you have heavy penalties, but enforcement is perhaps not our strongest point as a country. So, that's a kind of tough mix where organizations who proactively want to be compliant will kind of spend, a disproportionate amount of time and effort in doing so. But at the same time, you then have to compete with organizations and perhaps players that are not necessarily interested in being compliant. So I think that is certainly a big challenge. I think also on digital, and especially like, for example, we spoke of dark patterns and things like that. I mean, as a regulator, that is, this is a part of our code and we have to look at it. It is extremely difficult to find these violations if you start to go, I mean, you see them everywhere, but to have a systemic approach of actually tapping into this or getting them on because they are so prevalent, they are so everywhere. And yet, from a regulation point of view, it is difficult to find a systemic way of being able to identify these violations and processing them. That becomes a really, really big challenge in enforcement. And again, going back to the point of saying that, when I mean, in some way, what you realize is that it is really the self and really at the, at the most individual and organizational level, self-regulation and, the interest in building consumer trust and building a trustworthy brand is what probably needs to drive it. I think, at least in the initial phases, I think it will be things like audits, more than being able to track and monitor. And it'll be these annual kind of surveys or audits that will have to be done to actually surface what are the extent of some of these violations, and then kind of determine what a pragmatic corrective action or what a pragmatic way to make sure that enforcement and compliance remains. I think, I mean, to my mind, it is a huge regulatory challenge. I don't think it is, I mean, it is tough to make the regulation, but it is still much easier than it is to implement it and enforce it. And I think particularly with digital, governments and regulators need to get savvy with technology. We need to use AI to be able to monitor some of these things. We need, web crawlers and trackers doing all of this work. I mean, it's just not possible to do it with any kind of manual effort. So, and of course, I think, Shashank alluded to this also, is that, the pace of change is such that unless you have very principle-based laws rather than very prescriptive laws, by the time you're implementing it, the market has kind of moved ahead and moved on to a new format, new technology, which you are always trying to catch up on. So I don't necessarily have an answer, but I think I can just reiterate and reinforce the point that enforcement is tough, and it's not easy in this case.
Thank you so much for that. And I think a constant thread that is coming up all this while is about the shelf life of the legislation. Also, the fact that the legislation cannot function in a silo. And as Ms. Manisha mentioned, and Mr. Hegde was also talking about that for the first time, we are having a regulator who also has a digital aspect to it. So we are yet to see how it functions. On that bit, now we are talking about enforcement, especially with respect to typical kinds of industries. But there's also, I personally feel, and correct me if I'm wrong, that enforcement is also an issue when it comes to categorizations which are given in the Act. So I'll go to Mr. Shashank and would request him to tell us something about this categorization of significant data fiduciary, because the compliances there are heightened. The responsibilities are heightened. So, what concerns do you see around the criteria, transparency, and potential policy discretion behind this categorization? Because, to my mind, it will directly affect enforcement. Yeah.
Professor Gupta, again, good point to look at some of these things because, we started looking at SDS a long time back when, earlier versions of the law were sort of detailed. Yeah, it's unfortunate because I think the earlier versions detailed gave a lot of um, metrics on how the government would decide, how the enforcement bodies would decide, whom to call an SDF or not, because the compliance burden is quite high. Again, we'll have to see how this law is operationalized. This idea about categorization of fiduciaries or in to whom you enforce is coming from years back. Going on from GDPR to even principles earlier than. Again, how we operationalize this in 2027, going on on to 2030, I'm not sure. I think small companies can have a significant can do significant harm as well. So are we going to then make it only discretionary for the DPB to be like, okay, or the government to be like, okay, now you have to also, you are recognized an STF, or you also have to do the audits, etc., risk assessment, etc. So I think that these kind of classifications, for example, the Digital Services Act in Europe, right? Yeah, in the EU region, it also has a sort of okay, if you have 5 million users, which is 10% of, or whatever, 3 million users, 10% of the EU market, then you are a significant, whatever, service provider. I think these kind of metrics don't really work in the digital space. There are various ways to game them, I would say, to sort of circumvent the policy proposals. Also, I think big corporations have an onus to showcase responsible compliance, right? They're behemoths who depend on financial markets, who have a sort of public market persona to maintain. So I think they will largely comply with it. But the small players who kind of straddle the law, how will we catch them then? Maybe it's more important for them to do audits. So it's going to be a bit of a mess in my view. And I don't know how this will play out in the law. And it brings me back to the real problem, right? This is what I was thinking through, on your question, is that how have we framed this law? Unfortunately, there's a lot written about, for example, that we need to build the right to reasonable inferences as a data right. I'm happy to share that paper. It's from the Oxford Internet Institute. Once I stop talking, I'll put the link here. And it's also like a old paper now, right? So these ideas are already out there. We need to understand the digital markets, right? We need to understand which are critical decisions that companies are making. Is a company going to make a decision about my finances, about my health, about my employment, about my property, especially when you start integrating AI into these services? I think we need to start thinking about some of these critical sectors and how the sensitivities and the propensity of harm is very high in such. So whether the DPB has the framework to do this, whether they'll have to work with the ministries. I also want to flag that we are saying the word regulator here loosely, and I understand that. But in the traditional sense, the DPB is not a regulator. It is not TRI, or it is not RBI, or it is not, even CCPA or even CCI, right? So I think India has had a tradition of statutory regulators. Unfortunately, the functioning of this is another paper, maybe, or question, which I know a lot of legal scholars have written about. But I'm saying it still makes sense to have that statutory regulatory body, right, which is made in public interest. And it needs to be independent. Why? Because it is going to be in the interest of the public and not corporations or the government, right, or the executive. So, yeah, I think some of these ideas are a bit old, unfortunately, especially in 2027, they'll start looking very old. And we could have made a law that is built on harms, built on principles, as Manisha was saying, and I was thinking, built on how decisions are made in critical sectors. So I think the sectoral bit, Garima, is really important. Even when you look at AI, we've been starting to look at AI as a general purpose technology is going to become so, right? So how is it used in the healthcare industry? How is it used in the financial industry? How is it being applied to farmers? So I think we need to start now looking at that perspective. It's a bit scattered, but I think as Lagna was also saying, there are no direct answers.
Thank you so much for that. And that makes sense in the sense, particularly that, again, coming back to the same point that the law cannot function in a silo. We'll have to look at sector specific, maybe guidelines, governing principles, etc. I'll take cue from this and I'll move to Miss Lagna, particularly on the point that uh, while the data protection board is being talked about, previously all the limelight has gone to CCI for a while, considering the digital markets. And then we had the bill, which also came up with a similar categorization of CDs. Um, Now, given your background in competition law as well as data protection advisory, how do you see the interplay between DPDP's consent, data use, and transfer requirements and competition law considerations, especially since we have had the recent WhatsApp judgment? Yes, over to you, please.
Right. I think before answering that question, I just want to say about, cooperation and basically interplay between different regulation and how the cross-sectoral regulation is going to work. I think the problem in India that we have seen is that regulators don't really speak to each other. There is minimal to zero coordination and cooperation among regulators. And we have, especially in competition law, we have seen a lot of litigation around this, where try-related issues, were raised before High Court that CCI doesn't have the jurisdiction. IPI-related issues, went before the High Court, whether the CCI has jurisdiction or not to decide on these questions of law. So I think this is something this culture is sort of missing in India when we look at the regulatory enforcement scenario in India. The culture or the practice of regulators speaking to each other is not really there. Although for DPDP, I understand that recently the CCI did have meetings with the officials of new law is going to play out and sort of its interplay with competition law. Now, having said that, a little bit of context on the WhatsApp judgment. Basically, at the appellate stage, the NCLAT, which is the National Company Law Appellate Tribunal, held that WhatsApp had actually abused its dominance by not giving users the option or the choice to sort of opt out, and they were forcing a take it or leave it privacy policy, which amongst other things sort of decided how personal data will be cross-utilized across Meta's platforms and products. And what's important is WhatsApp's conduct was sort of examined in detail only after the CCI found that WhatsApp is dominant in the OTT messaging market. So that is the first step. I mean, I think competition law sort of kicks in, and abuse of dominance allegations can be looked into only if an entity can be said to be dominant in a particular market, in a given relevant market. So the NCLAT did agree with the CCI that WhatsApp is dominant and has agreed with most of the findings of the CCI, and some of the remedies have been overturned. But I mean, that's not relevant for today's discussion, so I'm not really going to go into it. But in effect, the NCLAT has largely agreed with the CCI stance, regulatory stance, that how a dominant enterprise decides to utilize personal data can result in abuse of dominance. It is something the CCI has the power to look into, and NCLAT has sort of upheld that position. And of course, I mean, it'll depend on what is the impact on the users, because here users were being denied their choice of, whether they are okay with the sort of cross utilization, cross use of data or not, and that conduct was considered to be exploitative in nature. So there can be instances, I mean, according to what we have seen, the recent precedent at least tells us that, there can be instances where privacy can be a factor of competition, where data can be can maybe misused or used in a manner that it can lead to competitive advantages. Although it's hard to prove how personal data can really get to that position, because personal data typically is replicable. It's non-rivalrous, and anybody can collect the same set of personal data from individuals. So keeping that in mind, whether personal data in itself can create competitive advantages and create market barriers, entry barriers or not, is of course, a question that still remains open for discussion. But in terms of whether the CCI has jurisdiction to look into data related issues or not, it can in certain cases. So that, of course, the jurisprudence is yet to be settled because the matter, if it goes to Supreme Court and ultimately if we hear from the Supreme Court on what the position should be, I think it'll be settled. But for now, the CCI does have this jurisdiction.
Thank you so much for that. Before I move on to our next panelist for a related question, I'll just like to remind all the attendees, feel free to put your questions in the Q&A section. I repeat, in the Q&A section, so that we can take it up towards the last 20 minutes of the session. Now, carrying forward the conversation that Ms. Lagna just had here, when we talk about regulatory overlaps, it can, while the problem is something that we can look at from the regulator's perspective, but if we really want to see in reality how it looks like, we have to look at the industry. So for that, I'll go back to you, Mr. Hegde. Particularly because you have been and you are a part of the senior management, I would like your views particularly on the cross-border bit of it, because as you see, oversee legal operations across India, Australia, New Zealand, which have different privacy regimes. While we understand the regulator's conundrum and we have an enabling law, but in the industry, what is the problem with it, or any challenge that you might want to highlight?
Sure. Thank you, Dr. Gupta. I think from a cross-border data transmission perspective, right? The journey from the early drafts of the bill to the final DPDPA Act itself is quite a significant change, as you all know. So we have moved away from a hard localization stance or mirroring and mandatory domestic storage processing for a wide categories of data to a more business-friendly negative list model, where the government will notify the countries where the data can't go for processing. And the rest of them are supposed to be, jurisdictions where transfers are permitted by default, is the model in which we finally landed ourselves in. For global companies like ours, this is a meaningful step towards legal certainty and interoperability, because we know that data processing cannot data processing at scale requires infrastructure building, and when you have that infrastructure, your ability to do that at effective cost and at the best, using the best technology, is best served when you can do all of that in one place, right? Or at least in few places versus doing it across the world. Where some ambiguity re-enters the pictures in these is in the rules, right? The rules confirm that personal data can be transferred out of India, but they also tie that permission to additional conditions the government may prescribe. Now, that suggests that the negative list approach may, in practice, may be accompanied by a process or a governance requirements beyond pure country-based, prohibitions, right? Before such transfers can take place. Until those conditions are fully spelled out, there will be a degree of structural uncertainty for long-term contracting and data architecture decisions. Is something which I think comes out strikingly for all of us on this topic. Now, our approach is to treat DPDP as directionally clear, but operationally evolving. Right? We talked. We throughout this discussion, we talked about various such topics where there is, some bit of clarity still need to emerge, and operational requirements still need to be prescribed. So we see this as directionally clear, but operationally evolving. We assume cross-border flows will remain broadly permissible, but we design our governance, contracting, data mapping to be robust enough to absorb additional conditions as and when they are notified. Right? compliance hurdle, but an opportunity to build a robust privacy by design framework that works across multiple jurisdictions is how I would put this.
Thank you so much for that. That was very helpful. I would invite anybody who is interested in asking questions to please put your questions on the Q&A box. Thank you for so much insightful details on various aspects. If I may, I will put up certain more questions and I pitch in anybody who would like to speak on it. And so yes, there were clearly many threats that we have identified, right? But particularly, when we talk about the law being made in a manner which is overarching, we talk about the consumer being prepared or maybe aware. We talk about the player being prepared from a governance angle. There are still certain institutional design challenges, especially from the Data Protection Board's perspective, particularly in terms of its capacity, independence, ensuring consistent enforcement. So I would like to invite you to give any thoughts on it, especially since we have not seen any aspect of rights angle in the law. Say right to data portability or any other similarly placed light, which we did see interestingly in the digital competition bill, which was floated and now is withdrawn. So, and of course, we don't have any harm-based qualifier there as well. So I would invite the panel to give comments on that. Yes, Shashank, please go ahead.
I think one thing that I've written about in the past is also if you look at the framework of the data protection board, right? You see how it's formed, then you see its functions, and then you see the powers or the process it needs to take to draw out penalties. It's a pretty tedious one. It's not very straightforward for the board to just listen to a case and issue a penalty, right? So I think, and I'm happy to share those articles. I think now they're behind the paywall, unfortunately, but I think that's also a very significant policy decision, which a lot of scholars and academics have then termed this bill as very business friendly. I understand that we shouldn't be adding disproportionate burden. But one aspect is that there are only penalties with nothing else. Second is, why are we making it so difficult for the DPB to do its job, right? There are so many hoops it has to sort of jump over to issue a penalty. So I think that aspect is a bit confusing. I've highlighted many problems in this bill, but one thing that in the rules I see, which I written about in the past also, that it wasn't clear whether the board could take action on its own, right? What we lawyers call as suo motu. I think in a country like India, where a lot of people will not be aware of this law and will not be aware of the existence of the DPB, I think the DPB needs to take up cases on its own, right? So I think the chairperson now under the rules can ask for a vote, bring up an issue and ask for a vote on to take up a matter. I think that's a very important change that I'm seeing. And I think now I'd like to wear like a looking forward hat because I think the analysis is pretty clear. I think if the board really wants to be a strong enforcer, it can be, right? In India also, we have a tradition of, if I can say this openly, we don't really stick very strictly to the boundaries that we create for our regulators or our enforcement agencies. I think if they really want to operate in a public interest way, I think they have the chairperson especially has a lot of powers, right? So looking at positively, and if they are, one other positive is they are saying that they'll consult with some experts and technical people. I think if they keep that avenue open, if we can submit some research to them saying that, DPP, we can support you in analysis on this, I think it's going to go a long way. So it really depends on how the government wants to run this. But it's going to be a missed opportunity if this is not done well. Sorry, very quickly, the other thing I'm pointing to is because I think it's an important point is the way the children's data is run. I think India is not Australia. A lot of times young people are introducing older people take the help of young people. There are shared devices in families. I think plenty written about this, nothing new. So it's a bit like the puzzling for me. I'm sure the industry has given so much comments to the government. It seems to be a political choice, but I'm not sure if how it will play out. So we are going to be back to square one. You're not going to protect children's privacy, and you have these elaborate rules which you'll selectively enforce against some companies. So yeah, I'm really confused about why we're doing what we're doing under the children's data. I'm actually happy to listen to others.
I invite others if they want to pitch in and give their views on the.
Yeah, just wanted to add something to what Shashank said. I think he's already covered everything that I probably would have said about, how the DPP should be constituted, about the selection committee and all of that. I think the only thing that I want to add is something. This is something that we saw in the Competition Act, which got challenged on constitutionality grounds before the Delhi High Court. That the chairperson has a second or a casting vote when it comes to taking judicial decisions, and that was considered to be not permissible because a judge cannot have a second vote or a second say in matters or which sort of decides the matter one way or another. So I think that is just one of the point that I wanted to highlight here when we talk about powers of the DPP and powers of the chairperson and the members. So
Thank you for that. We have a very interesting question actually, and I think somewhere we have touched upon it while Mr. Hegde was talking about the health sector, wherein the type of data that you collect carries with it larger responsibilities. We also touched upon it somewhere because when Ms. Manisha was talking about dark patterns and different types of data collection, especially when we are talking about a niche area of data. So someone is asking, we have an attendee asking, what about mental health apps? How do you see the problem? Does it get magnified? Do you see that it can be curtailed, or there would be again industry specific guidelines that would be needed? I invite any one of you to pitch in.
well, I mean, healthcare data, to be very honest, is one of the more sensitive categories of data sets that organizations process. So, I mean, to my mind, even conversations on mental health apps that patients have with their therapists, be it, and apps they can be aggregators, they can be, they can have their own employed or consultant therapists who are providing, they may have their own panel of therapists who are sort of providing therapy services. Irrespective, I think the conversations and the content and everything would be personal data because a lot of the conversations can have, identifiable information. It can identify the individual. So, and it's very difficult. I mean, what part of a conversation do you consider to not be personal data and what part do you consider to be personal data? So that sort of bifurcation cannot, and organize at an organization level, I don't think it's possible to do or to do within an app. So I think for organizations who are operating mental health apps, I think it will just be easier to sort of consider the entire conversation or the chat to be personal data because some parts of it may have the capability of reasonably identifying the data principle.
Thank you. Thank you for that insightful.
I think just to just to add, I think to that question on mental health, I think mental health is something which even in the non-digital world, there is a lot of need for privacy around it, and therefore I think as Lagna rightly said that it's just I think better for organizations to be extra cautious and go the whole hog in terms of interpretation of any privacy principle for such apps just because of culturally, how consumers tend to look at mental health in India.
Thank you so much for that. Yes, Shashank, please go ahead.
I just want to add, we've done some research and it's due for publication, so it'll come out soon. I'll share the link to our website where we analyze some popular dating apps, right? I'm not talking about mental health apps. And we try to see we try to just compare basic IT rules required, right? And these are really, I'm not going to name them here, but it's really, really popular dating apps, right? None of them were compliant. At least just from the public information that they had shared, none of the policies were in conjunction with the law, right? So when we talk about enforcement, I'm really skeptical, right? Because as we're seeing, even the because if the Ministry of IT is the regulator, which is a bit like mind-boggling for a lawyer, but if the Ministry of IT is the regulator, it is selectively enforcing its laws, right? It's not standard enforcement, unfortunately, because it can't standard enforce. It doesn't have the capacity to enforce these laws in a standard manner. So I think we are heading to a legal regime that is selective in nature and by design, very unfortunately, if I may say so. And just to be a bit more realistic about how this law will get operationalized. Yeah, I don't think that's a good position to be in. And I don't think other countries, especially if we're talking about signing agreements with other countries about data exchanges, I don't think they'll be looking at this in a good manner. If the EU doesn't consider US privacy law as protective enough to share its own citizens' data, I'm sure it's not going to be looking favorably to us. So some of these policy positions are really bizarre to me from an Indian government perspective as to why would it not create India as an attractive privacy protecting regime in a global market data economy. So yeah, some
Thank you so much for that, Shashank. If I may, we have a follow-up question, not a follow-up question, a related question, basically. Nivedita is asking, a lot of cohort studies are being run, especially aging studies in institutes like the Center for Brain Research. These studies use digital health technologies to capture data in lifestyle interventional trials. This data may not necessarily be identified, which can be an issue. How can guardrails be put in place, especially while taking consent? Secondly, how do researchers navigate this with international collaborators?
think there is an exemption very clearly laid down for research purposes. It's very broad and it's a bit scary because it doesn't define what research purposes in my view. I might be mistaken, so please correct me. But I think my immediate answer to your question without thinking too much, Nivedita, is I think there's a very clear, like broad exemption cast out for research purposes along with state, like public order, national security.
Thank you. We have another question, particularly on social media platforms and hosting sites, which often claim they are not responsible for user-generated content, citing Section 79 of IT Act, which provides them immunity to some extent. However, this protection comes with conditions. They must comply with guidelines, remove unlawful content, and not tamper with content. So again, there's a flux between IT Act, Data Protection Act. Yes. Any thoughts on this?
Sorry, I'm not clear about what the question is.
I think it was more of a reflection wherein the person was talking about how IT Act interplays and what is the any thoughts on the IT Act? Anybody, any panelist? I would invite some comments on that.
I think
That would
if I may
require.
just, sorry, Shashank, please go ahead.
No, please go ahead.
I was just saying, I think the thought was more about intermediary liability and how intermediaries are not supposed to. I mean, if they, of course, follow certain guidelines and meet certain thresholds, they'll not really be responsible for content that is hosted on their website, which I think is a principle and a doctrine that has come up, a few decades ago. And to my mind, I think it's a legitimate doctrine, and there's as a concept, I don't think it's flawed. But of course, there are nuances to it. And yeah, I mean, I think that'll require maybe another 1 hour discussion on when can intermediaries be liable for user hosted content. So yeah.
Thanks a lot. Yeah, please.
Sorry, Masoda. Yeah, just to add, I mean, I've been thinking about this for a long time. I think one new thing I'd like to point out, maybe I don't know if we discussed here, is that although the safe harbor rule has helped social media grow, the government doesn't look at it favorably anymore. So if you look at court arguments, not necessarily, whether it's the Karnataka High Court case, various cases in Delhi High Court, Bombay High Court, Kerala High Court, I think the government has been strongly arguing and actually creating more and more conditions to acquire safe harbor, which basically flips the default uh, um, protection, right? And again, I'm talking about like selective enforcement that the government does here. So yeah, I think these two regimes. It's unfortunate that we're not rethinking our IT Act. I'm not saying the Digital India Act and that thought process was the best, but I'm just saying that this law now is really old. If you look at the deepfakes rules that the government recently proposed, it's really bizarre, right? Because the government itself, in the recent AI governance guidelines, said that the IT Act is obsolete and said that intermediaries are not strictly like AI chatbots are not strictly intermediaries, or at least maybe the definition is so broad they're still intermediaries, but safe harbor doesn't apply. So we're coming to a position where this law is like the government committees themselves are saying it, right? So I think we need to rapidly rethink our IT law. Many countries, even similar countries to ours in the global south, have started thinking. So I think just using the safe harbor regime and the rules under it to regulate a vast amount of digital entities, I'm not sure if it's going to work out. So I think yesterday there was a order to send to VPN services about maintaining privacy and all that. And again, it's a bit of a stretch of imagination how VPNs are being applied to intermediary definition. It's a broad definition, I understand, but at least that wasn't the idea behind it. So yeah, a long story short, I think it's going to get a very confusing regime with the IT Act operating alongside the DPDP. And maybe because they're housed within the Ministry of IT, there will be some confluence, hopefully there, but it's not promising.
Thanks a lot for that. If I may just quickly, the last bit, I wanted to reach out to Ms. Manisha on the point that now we have been talking about the enforcement angle of it, but since we have to talk about advertising also when we talk about data protection and the consent rules, um, especially with respect to the problem of unethical ads, do you see that Data Protection Act maybe in the near future would be reshape the way advertisers target consumers in the first place?
Yeah, so I think, most of the advertising laws right now are more to do with the content of advertising. I mean, if you see most of the horizontal laws, you look at the Cable TV Act, or you look at the Consumer Protection Act, or even, in fact, any of the sectoral ads. I think right now, most laws have not touched upon the delivery of advertising, which is, and the peripheral issues around targeting and delivery of advertising and how it is actually served and presented. But I think that is really the expanded world of advertising, as it were today. And I think, all of these discussions we are having, so be it the IT rules, be it, the DPDP Act, everything is kind of trying to now, occupy that territory, which is, which needs, in that sense, it needs its own set of rule makings. But possibly, it's a little tough to overlay some of these new kind of rules and new kinds of understanding of advertising onto existing laws. And I think, Shashank, you briefly spoke about the new laws which were coming in on, synthetic media. So I think that is a challenge, and I think it reinforces some of the things that I was saying at the beginning, that this everything is just so fast evolving, and I mean, in some way, I think it's not just a challenge with India, but possibly everywhere. Regulation is struggling to keep up with how fast technology is growing and some of the new challenges it is facing. And again, I think the only thing for regulators to do is to kind of listen to people more, to be more consultative in the approach, to really look at what are the use cases. And like I think someone said, what is the actual consumer harm? Because I don't think regulation is here to regulate the technology. What we want to regulate is consumer outcomes. Are we creating an environment of trust or mistrust. I think that is what regulation should try and solve for. And therefore, again, I think more principle-based, regulation, more consultative approach, and I think just a slightly more agile way of dealing with today's challenges, I think would be needed.
Thank you so much. Thanks a lot. Since it's almost time now, we would like to close the session. I would just like to highlight a couple of threads that we talked about continuously in all this discussion. I would thank all the panelists for giving their insightful thoughts on the topic, especially since it is the talk of the town right now. So we saw that how there's a lack of clarity on the law's language, although the legislature's intention seems to be in the right direction. There's requirement of some sort of clarity on the categorizations, maybe on the structural uncertainties that we have. But we also talked about how conduct of the market players also has to be informed, because it's sort of a continuous compliance and it's not only a compliance, it's more about responsibility and responsibly using the user data. With that, I think it was a great conversation. Thank you to all our panelists for their thoughtful insights, and to the audience for engaging with this important conversation. It just marks the beginning of a long regulatory journey, as was evident from our conversations today. And discussions like this help us understand not just the legal text, but the practical, ethical, and sectoral implications. We hope this dialogue contributes to a more informed and responsible data ecosystem, and it's not a one-time conversation, and that we can continue it further. We thank Advertising Standards Council of India once again for this collaboration, and we look forward to propose something again in this direction in the future. Thanks a lot, everybody.
Thank you so much.
Thank you so much. It's been a pleasure being part of this. Thank you.
Thanks a lot for taking time out. Thanks.
Bye-bye, everyone.
Bye.
Bye, everyone. Have a good weekend.